matter before the court is Washington County 24227, Charles Keegan versus the estate of Phyllis Bradbury et al., the Holmes. And if I see counselor present, if you would introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellants.
Good morning, Your Honors. Gerald Schofield for the appellant, Charles Keegan.
Good morning, Your Honor. Benjamin Campo, counsel for the appellee, Craig and Melissa Holmes.
And Barry Mills, and I am the attorney for the estate of Phyllis Bradbury and the two personal representatives, William Bradbury and Barbara Ann Shuffler.
Thank you, counsel. We are being streamed live on the web, both by audio and by video. And Mr. Schofield, if you're ready to proceed, we'd be happy to hear your argument.
Good morning, Your Honors. May it please the court. The appellant entered into a contract with the appellee estate to purchase 7 Lower High Street in Eastport, Maine for a certain sum of money on the other condition that he also receive a right of first refusal on an abutting parcel of land at 1 Lower High Street. The estate accepted that offer by signing the contract, only to later breach that other condition by selling the property to the appellee Holmeses without first offering it to the appellant. We are before you today because a non-lawyer drafted the language from the purchase and sale agreement, language that was drafted unartfully at best. However, the language was meant to be binding additional contractual term and not a wish, and the contract was seen, agreed, accepted, and signed by the parties thereto. The intent of Section 26 of the purchase and sale agreement was abundantly clear and had no other purpose other than to give the appellant what he bargained for, contractual right of first refusal to buy the abutting property. The appellant knew it, the realtor knew it, and the appellees knew it because they acknowledged it in writings that were ignored as evidenced by the court below solely due to a realtor's poor draftsmanship within the contract. A right of first refusal is not a standard term in a purchase and sale agreement. In fact, it has no business within a purchase and sale agreement unless the parties intended it to be there. That is why it was added as an other condition under Section 26. Should this court uphold the orders issued by the Superior Court below, it would, in essence, validate the fact that Section 26 of the purchase and sale agreement might as well have read out the Boston Bruins win the Stanley Cup this year. It is long-standing law that courts are not to render contractual provisions meaningless, but that is exactly what was happened here. The Superior Court looked at the 20 words of Section 26 to determine that the language was precatory, and, as such, ruled solely as a matter of law. It did so without considering any extrinsic evidence, which the court should have done because even the language of 26 itself could have two separate meanings. 1, precatory as was ruled, or 2, as a legally binding provision under other conditions under the purchase and sale agreement, it having no other purpose for being added there. Under the law, the Superior Court had the authority to look to determine if there was any latent ambiguity, an ambiguity that did not appear on the face of Section 26 or within the contract, but which was certainly clear from the intent of the parties and the consideration of any evidence presented before the court below. I ask this honorable court to do so today. If it does, the court will correctly see that the parties meant to have 26 as a binding other condition of the contract, both offered and accepted by the signatures of the parties on the purchase and sale agreement. Simply stated, this court has the ability to right that wrong and to make it clear that parties cannot eke out of contractual obligations merely because of poor draftsmanship of realtors. This court can overturn the orders issued without consideration of all the facts which were viewed in the light most favorable to the appellant below, and remand this matter back to the Superior Court with a finding that the purchase and sale agreement contained a valid right of first refusal and for fair hearing based upon...
Counsel, I see that the green light is on.
I timed that well, Your Honor.
You did very well. I was taken by your opening line about a non-lawyer drafted this, and that's why it's drafted so poorly. Let me suggest we see plenty of things drafted by lawyers equally poorly, but that's a whole,
I'm sure.
that's a whole nother point. Can we, this right, what you're alleging to be a right of first refusal was contained in a purchase and sale agreement for the abutting piece of property, correct?
Yes, Your Honor.
That sale went through.
The subsequent sale?
The sale of 7 High Street.
Yeah, the sequence was my client, the appellant, purchased 7
Right.
Lower High Street. and
So
then
the
one
purchase
was-
and sale agreement that contains the alleged right of first refusal was for the purchase of 7 Lower High Street, right?
Yes, Your Honor.
That occurred before the sale to the homes.
Yes, Your Honor.
So I guess I'm struggling. It said condition of sale. It didn't seem like there was anything that the sale of number 7 was conditioned on. I mean, the sale went through.
It would be the appellant's position that him entering into the contract in the first instance was conditioned upon him being able to receive the right of first refusal to also buy the immediately abutting property. And but for the seller's agreement to do that, my client wouldn't have bought 7 at all.
But the sellers didn't have to ever sell the abutting piece of property. So whether or not he was going to buy number 7 couldn't possibly have been conditioned upon obtaining number 1 because they didn't have to sell it.
They didn't have to sell it in that instance, in that moment, but the last will and testament of the decedent under Article 6, which is filed with the Washington County Probate Court, does mandate a sale of the property, in which case it would be our position that the personal representatives in this matter would have had a fiduciary obligation to sell that property in accordance with the terms and conditions of the decedent's will, which is why a right of first refusal was considered for that sale within the contract between these clients.
I think everybody in this courtroom would agree, have a meeting of the minds, that you would like to have this judgment vacated.
Yes, Your Honor.
You see where I'm headed with that? It's precatory language. We all agree there's a meeting of the minds that you would like something to happen, but that is precatory. It's not conditioned on anything. It's just a position that you hold, and we recognize that you will hold it. Isn't that an exact analog of what happened here? And your client would like to have an opportunity to have a first refusal on it if they're going to sell it.
Your Honor, I would respectfully disagree and state that the reason that the Section 26 was added in and its other conditions, it doesn't say other wishes, it's a condition. And a condition is something that must happen. And I will agree with Your Honor that the language, albeit poor, was put there by the realtor.
But isn't that the problem? That condition, as you're alleging it, could not have happened prior to the purchase of number 7.
Well, the condition couldn't have happened prior to my client purchasing and entering into the purchase sale agreement. Can you please rephrase
Or
Your Honor?
completion of the sale of number 7. In other words, it wasn't a condition of the sale of number 7.
It was a condition of my client entering into the contract to purchase number 7 and part of the basis and benefit of his bargain under the underlying purchase and sale agreement. I will enter into this contract to buy 7 Lower High Street from you on the condition that you also give me a right to buy the abutting property when the estate sells it.
Well, I'd like to explore the language of this, what you are referring to as a right of refusal, is it would like the right of first refusal on the sale of the abutting lot if ever sold. So it goes on for an indeterminate time. It doesn't explain the procedures that you would use. It just says, I'd like it if someday you sell it. And so I'd like your response to a paragraph in the restatement, third of property on servitudes, section 3.4, which says, strong justification would be required to conclude that any right of first refusal that imposed vague procedures or long waiting periods was not an unreasonable restraint on alienation. So if we were to try to shoehorn this into an actual condition, wouldn't we have an alienation problem?
I don't believe so, Your Honor, because it would be my position that the right of first refusal is personal to the holder thereof, which is the appellant, Mr. Keegan. Section 26 applies to the buyer. It says the buyer would like the right of first refusal. So he is the person who is the one who's supposed to be given the option to match any offer received by the estate and no other person, in our view. And the estate, as I already mentioned, was obligated to sell that property due to a probated will that was on record in the Washington County Probate Court.
So it doesn't say it's personal. It doesn't say how long he's got to contemplate the refusal. It doesn't say anything about the procedures by which the first refusal is exercised. And isn't that what the restatement is talking about as being too vague to enforce?
I certainly can't argue with that there's not more details within the contract. That would be disingenuous. But I will say that there are often rights of first refusal that are not artfully drawn and don't contain all of those things, and they can be upheld. And we would say in this instance, the intent and meaning of Section 26 and why it was there was clear.
Do you have a case, a decision, where they use this, where there's similar language and that was deemed good enough, the would-like conditional tense?
I did not find one exactly similar to this, Your Honor.
There don't appear to be additional questions.
Thank you, Your Honors.
Thank you. And Mr. Campo.
Madam Chief Justice, Associate Justices, may it please the Court. As I previously stated, my name is Ben Campo. I represent the appellees in this matter, the purchasers of the subject real estate, Craig and Melissa Holmes. The Superior Court did not err when it dismissed the appellant's complaint. This Washington Superior Court, County Superior Court, was correct. First, in holding that an interpretation of the contract, an unambiguous contract, is a matter of law. That's long-established precedent by this court, and the Superior Court held to that and proceeded that way. And then the Superior Court looked at the language in the contract that was seeking to be enforced, and finding that it was unambiguous, then correctly concluded that it was not a contract. And specifically, it's paragraph 26, as Attorney Schofield was discussing, and that specifically states, buyer would like the right of first refusal on the sale of a budding lot, if ever sold. That language is completely clear, with meaning that virtually everyone in this courtroom and outside this courtroom can understand. And so in the court's interpretation, the court was correct.
Green light is on. Why is that provision there?
Why is the
Why does it exist?
the other conditions?
No, why does it say he'd like it? What's the point of that provision?
I think it speaks for itself, is that he wanted to let the sellers know that that's what he would like in the event that that real estate was ever sold.
Well, he could tell them that. I mean, why was it embedded in the language of the contract itself?
I mean, it says it's a condition of the contract.
It's a condition, but, Your Honor, you were correct when you identified the fact that the sale that was covered in this purchase and sale agreement was consummated, and there was no other paperwork that spoke to the condition concerning the right of first refusal. So, in so much as a condition, it's really an aspiration.
Well, counsel, there could be other conditions inserted that require sort of after-the-fact action.
Absolutely.
You know, the seller will improve the property or remove certain things from the real estate. And those are after the sale is consummated. Those actions are contemplated.
And the difference in that is the language you just used, Your Honor, in describing what the conditions would be. Seller will remove the property. That's clear. That's unambiguous. If a case were brought that the seller failed to remove the property after the sale of the real estate, and the language stated within the purchase and sale, seller will remove the real estate within 45 days after the consummation of sale, and the seller failed to do that, that would be enforceable as a breach of contract because it's a clear breach. It's an unambiguous breach. In this case, we have unambiguous language that doesn't provide any meeting of the minds.
But to Justice Connor's point, why put that in there if it didn't have some significance?
I'm only guessing, really, because I represent for one thing, I don't represent any of the parties to the contract itself, and so I'm representing the third-party purchaser, and I think it was to let the seller know, we know you have other land to sell, we are interested in purchasing that land, in fact, we want to be at the front of that line for that land.
We're
And
here on a dismissal, though. I mean,
Correct.
so to the extent people are coming up with ideas about what it might mean or could mean, isn't that then a fact question so that it can't be determined on dismissal as opposed to, in other words, that it may ultimately turn out to be only merely precatory without consideration, without any sufficient definition to be enforceable. But given that it was included as a condition of the contract, does that make it a fact question?
No, Your Honor, and the reason why is because of the standard of review for unambiguous language in a contract. The language in the contract's unambiguous, and for the court to find ambiguity in this language sets up a horrific situation where courts are finding ambiguity in virtually every real estate contract.
So your argument is that it stops at plain language. It's not ambiguous. We don't mess with anything outside of the four corners of that sentence.
That's what the law says.
If we did say that it is ambiguous, and we turn to extrinsic evidence, you would agree then that dismissal would be improper. I'm looking at the complaint where it says the estate and its personal representatives acknowledge the validity of the existence of the right of first refusal, etc., that they actually said out loud in writing and in person your right of first refusal. So 12b-6, taking as true the allegations of the complaint, would require dismissal, would require vacating the dismissal.
Could you, I'm a little confused by the question, Your Honor.
Okay, let's say, I'm not saying we would, but let's say that we found the language to be ambiguous. So then we look at if it's a 12b-6 motion, we look at the allegations of the contract,
Yes.
complaint. And the complaint here says that the sellers acknowledged that there was in fact a right of first refusal. So the court couldn't possibly grant the 12b-6 dismissal, taking that as true.
As that's worded, yes, Your Honor.
Okay.
Except I think that we then get to the contract itself. And so whether the sellers acknowledge it or the buyers state it, the contract doesn't say it.
Right,
And so-
that would be a good case, a big factor for the trial, but on the four corners of the complaint, it says that they acknowledge that there was a right of first refusal.
Right, that's an allegation which imputes knowledge of the sellers from the buyer.
Right.
And I think that's a factual allegation that probably, while it's accepted as true, I think seller's acknowledgement is a bit of a reach to accept.
Yeah, I'm
as
not trying to
true.
go to, I'm just trying to say, you're saying it stops the plain language. If it didn't, then we'd have to vacate the dismissal under 12b-6.
You're saying it doesn't matter that the sellers may have acknowledged it if it wasn't a contract term in the first place?
Yes, Your Honor. That is exactly what I'm saying, because if you're not bound by contract and you're acknowledging something, that doesn't mean you're bound by something you're not bound by. And so my point being in that situation.
Well, actually, I think it's more whether it exists, whether the right of refusal, first refusal exists or not. They would say it does, and you'd have to take that as a proven fact for 12b-6 purposes. But if it goes to summary judgment or to a trial, then it would take that further step you're talking about.
Yes, but when the court gets an unambiguous contract and is asked to review that, it's on the court at that point to
Right.
factor out those other issues and get right.
I think we're all saying the same thing in different words.
Okay. Sorry, Your Honor, for repeating that. I think it's also important to note that there were professionals. It was mentioned a real estate agent was there. This was inartfully drafted, and lawyers inartfully draft documents all the time. But there was no other, within the record, there's no other reference to any other document stating that there was a right of first refusal, only the condition in the contract.
Thank you.
And I think that's fatal to the appellant's claim.
Thank you, Mr. Campo.
Morning, Your Honor.
Good morning, Mr. Mills. Can
Hi.
I follow up a little bit on a question that I think Justice Meade was asking, as well as Justice Connors?
We're talking
Even
about
if
the-
the language of the term is precatory, when we talk about whether something's ambiguous, don't we start with the language of the specific term, but also look at it in light of the contract as a whole? And so what we've got here is allegations and a contract that indicates that perhaps your clients acknowledge the right of first refusal. It was stated that it was a condition of the sale of Lot 7. Doesn't that give, and there had to be a purpose for including that, doesn't all of that, at least taken together, at least raise a question as to the ambiguity of the term and whether it ought to be sussed out as a fact question?
If this contract is, got to be ambiguous, then any contract containing precatory language would also be ambiguous. Buyer hopes to pay the deposit by December 1. Is that an enforceable contract? Is that enforceable? Is it ambiguous?
Your client, though, took action as if it had meaning. They called Mr. Keegan and informed him and asked him if he wanted to exercise, did they not?
Well, yes, they knew that he was a potential buyer. And I suggest that's probably the purpose of putting it into the contract. Look, I'm a potential buyer here if you want to sell. And if I'm a seller and I know there's a potential buyer, that's going to be my first call. I might avoid a broker's commission.
So you're saying it's no different than me going to my neighbor and saying, if you ever sell, give me a call if you're ever interested in selling. There's nothing really enforceable or contractual about that, but they certainly at least know that I might be interested. And
Certainly, and when you say, when you characterize this as a condition, which was the caption, but what is the condition? I hope to buy the property. I wish to buy the property. Okay, I agree. That is your wish. But I haven't granted it. And we go back to one of the most memorable points of Contract 1. Many years ago, in an out-of-state law school, was Owen versus Thompson. And that was a case that came out of Bucksport. And I cited that in my brief, in which one said, I'd like to buy your property. And the fellow said, I couldn't sell it for less than $16,000. I said, I agree. There was no contract. And the professor said, beat it into our head. What constitutes an offer for purposes of a contract? And Owen versus Tennyson, he said, is one of the primary cases in the law of contract. And perhaps others here in this room also experienced Owen versus Tennyson in Contracts 1. It is basic to the law of contract that there must be an offer and there must be an acceptance. And here we have neither an offer, we have an expression of a wish. And that's all that we have. And if this is valid, think of what this does to lawyers drawing future contracts. You're going to end up with a mess. I mean, if this will suffice, then think of the awful documents that are going to come in front of you that require interpretation. Is it ambiguous or is it not ambiguous? And there are careers to be made that should not be made on that issue alone. Clean up the law of, at least don't mess up the law of contracts. We have a good working system right now that it works. I was assigned to the rule against perpetuities. And the rule against perpetuities, I'd be happy to argue that. One of the...
Well, I believe his argument is that it's personal to him, so it's limited with a live person. What's your response to that
There was
argument?
nothing in the contract that says that it's personal to him. You give me a right of first refusal.
well, it doesn't say that his heirs and assigns are bound, only that he's bound.
Doesn't say either way.
Okay.
Doesn't say either way. We can only
Under the
speculate. We
statute, it's either the common law rule against perpetuities, life and being plus 21 years, or if in fact it would vest or did vest within 90 years. And if this was a right of first refusal that was contractually bound, it's already vested, right? Because
No, it is not vested. And an option is not a vested contract.
It wasn't vested at the time, but isn't it vested now, within 90 years?
No, it never did become vested. It never became more than a contractual right. The first, there was cited in the appellant's reply brief, Van Dam versus Speckler. And when I first saw that, I thought, oh gosh, here's a problem. Van Dam versus Speckler said a right of first refusal becomes an enforceable option upon its exercise. But there's nothing in the Van Dam case that says the option is a vested interest. In fact,
But didn't he try to exercise the right of first refusal within 90 years?
right, and he couldn't do it, and he never did. If he had, Black's Dictionary, talking about vested, to confer ownership on a person, to invest a person with full title. You have to have a right, a vested, a final right. An interesting case is Klassen versus City of Newton, a 2015 Kansas case which is admittedly unpublished, but Klassen versus Newton contains a lot of citations to other authority around the country saying that an option is not a vested interest. And when he exercised his right of first refusal, if he ever did, he would have acquired at most, at that point, an option. He would not have a vested right until he acquired ownership. An option is not a vested interest in property, and I found no cases contrary to the Klassen decision. If you have any other questions, I'd be happy to respond to them.
There don't appear to be. Thank you.
Well, thank you very much.
And Attorney Schofield.
Thank you, Your Honors. Thank you, Counsel. The whole premise of why we're here is a 12B6 motion to dismiss. And the court has to find that there is absolutely zero basis upon which the court could grant any relief if every one of the facts under the complaint is taken as true. And I don't think that the court below can do that. There is clear discrepancy in the language of 26 in whether it's a condition meaning a binding condition, or whether it's merely precatory language. That in and of itself would allow the court to explore ambiguity. Either overt ambiguity, or the law also allows the court to look into latent ambiguity, which isn't apparent on its face.
So are you saying any aspirational language in a contract is ipso facto enforceable?
I'm not saying any language. I'm saying the intent of the language in this contract, phrased in this particular
Because
manner
it's
as
under
a
a heading
condition.
that says conditions.
That's correct, Your Honor.
And
So it's
that's what you're basing ambiguity on.
correct, because it can be interpreted in more than one way. And I think that when you look at the other record evidence in the court below, there's a recorded affidavit wherein Mr. Keegan says, I have a right of first refusal.
But just focusing on the plain language of the contract, it's awfully vague. And doesn't that suggest that it was only meant to be aspirational?
I don't believe so, Your Honor, because it would have no purpose or intent of being there if that were to be the case.
So what if it said condition, I would like to have an easement across the seller's property to get down to the ocean? Have they created an easement by simply saying in there, I'd like to have one?
It would depend on the circumstances of how it was added and what it said.
It says, I would like to have an easement.
If you were only going to buy that second abutting property, if you got an easement to be able to get to the property you're purchasing, then sure, I would say that's valid and enforceable. And the law actually says that if a location of an easement is not written into it, then the holder of that easement, right, can situate that easement on the face of the earth. So I would say it is a contractual obligation.
So precatory language under a heading conditional becomes enforceable.
In the circumstances of the purchase and sale agreement of which we are talking about, I would say yes, it does, Your Honor, respectfully.
Does it make clear that the condition is requiring right first refusal is related to the actual sale of property? Again, the sale was consummated in Section 7. The language says conditional,
The language says other...
but not as to the sale.
No, it says a condition of the contract, of the purchase and sale agreement, looking at the entire instrument as a whole, as the court should have done, is that I'm entering into this contract with each one of the 26 to 29 sections, I can't remember exactly how many, Your Honor, need to be given meaning and intent. And if we just scribble out one that says, well, it says would like to, but also references the map and lot number with specificity. I know exactly which property, when I go into the town of Eastport's tax assessor's records, that he contracted to be able to have a right of first refusal over. There's no ambiguity there.
Thank
And
you,
he knew,
counsel.
based upon the estate and the probate records, that that property needed to be sold, and he said, if I'm gonna buy this one, I wanna secure my right to buy this by the purchase and sale agreement.
Thank you, counsel.
Thank you, Your Honors. I appreciate it very much.
Thank you for the arguments this morning. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. However, as is also our usual practice, I understand, Mr. Schofield, that this is your first argument in front of this court, and we would invite counsel back to take the greetings of the court.